So what happens when a country's leader gets sick? I mean, really sick. How much are we, the public, supposed to know? It's this classic tug of war, right? The president's personal privacy on one side and our right to be informed on the other. Today, we're going to dive into this exact tension, all through the lens of a really fascinating legal battle in the Philippines. So let's just put the core question right out there. Do you, as a citizen, actually have a right to know if your leader is seriously ill? And this isn't just some thought experiment. It's a real, thorny constitutional debate that gets right to the heart of public trust and what transparency in government actually means. Now, the whole legal basis for this entire fight comes straight from the Philippine Constitution. And the key, the absolute pivot point, is that one little word, shall. The public shall be informed. See, that sounds like a command, not a suggestion. But, as we're about to see, how you interpret that single word, well, that's where everything gets incredibly complicated. And back in 2020, that constitutional command was dragged right into the spotlight. One concerned citizen decided to put it to the test, taking his fight for answers all the way to the nation's highest court. Okay, so this brings us to the person who started it all. Who exactly was he, and what was it that pushed him to take such a huge step and actually sue the president? The man's name is attorney Dino de Leon, and he didn't just write a letter. He used a serious legal weapon, a petition for mandamus. He was trying to get a court order to force the president's office to hand over all medical and psychological records from day one of the presidency. So what in the world is a mandamus? Think of it as a court's way of saying, you have to do this. It's your job, it's not optional. It's a legal tool you use to force an official to perform a specific, non-negotiable duty. And de Leon's whole argument was that telling the public about the president's health wasn't a choice. It was one of those non-negotiable duties. You know, this petition didn't just come out of nowhere. De Leon pointed to a whole pattern of things that had people worried. There were these frequent last-minute cancellations of big events, long stretches, sometimes up to a week, where the president was just gone from public view. Plus, the president himself had talked about having multiple health issues, and there was even one live press conference where he seemed, well, incoherent. So the demand was made, and it was backed up by all these public observations. The gauntlet was thrown down. How did the Supreme Court respond? Well, the court's answer came back, and it was a flat-out no. They dismissed the petition, and their main reason? They said the petitioner didn't establish a prima facie case. Now, that's a key legal term, so let's break down what it actually means. Prima facie. Sounds fancy, right? It's just Latin for at first sight. In the legal world, it basically means you have to show up with at least some credible evidence just to get your foot in the door. The Supreme Court was essentially saying that even at a first glance, the evidence just wasn't strong enough to even begin to force the president's hand. And this gets to the absolute core of the court's thinking. They had to figure out if disclosing health records is a ministerial duty, something the president must do, no questions asked, or is it a discretionary act, something where his office has the freedom to decide if, when, and how they share that info. The court decided it was discretionary. So why wasn't the evidence strong enough? Well, the court did not mince words here. They pointed out that most of the proof was just online news articles, and they called it hearsay evidence, twice removed. It's like hearing a rumor from a friend who heard it from their friend. It's not direct proof, and the court decided it had zero legal weight, not nearly enough to prove the president was seriously ill and trigger that constitutional command. But hold on, the story doesn't end there, because this decision wasn't unanimous, not by a long shot. One justice fired back with a powerful, detailed dissent, basically arguing that the rest of the court got it completely wrong. That justice was Marvick Leonin, and he argued that by throwing the case out on a technicality, the court was dodging a question of extreme transcendental importance. For him, this wasn't just about legal rules. This was about the fundamental health of the entire democracy. And this one quote from his dissent just perfectly captures his warning. He said that shielding the president from this kind of public questioning doesn't just hurt public trust now, it creates a dangerous, atrocious precedent for the future. Basically, an open invitation for future leaders to hide their own inability to govern. His dissent really hammered home a few key points. 1, the president's health is a genuine public concern. 2, we have a right to know if our leader can actually do their job. 3, just dismissing the case means the court is avoiding its own duty to settle a huge constitutional question. And 4, and this is a really sharp critique, he said the court shouldn't be making the government's arguments for it. So you've got the official court ruling on one side and this fiery dissent on the other.
Let's zoom out a bit, because this is about so much more than one lawsuit. It's about that fragile thing we call public trust.
As you can imagine, this ruling set off a huge debate all across the country. Legal experts and scholars all started weighing in, wrestling with that same central question. Is that constitutional command a concrete duty, or is it all up to the president's discretion?
And this is where we get a really compelling counterargument from Professor Dante Gatmaton. He offers this brilliant, nuanced take. He says, look, the duty to tell the public, that part is ministerial. It's non-negotiable. The only part that's discretionary, he argues, is how you release the information, not if you release it.
When you boil it all down, this case is the perfect snapshot of a timeless democratic dilemma. It's that constant friction between a leader's personal right to medical privacy and the people's fundamental right to know if the person in charge is actually fit to lead.
And that brings it all back to us and this final, crucial question. The Supreme Court drew its line based on legal rules and evidence. But in a democracy, where should we, the people, draw that line? How much transparency should we demand from the person we've entrusted with the most powerful job in the country?